We're supposed to commit all the papers to memory.
Distinguished delegates, can I call the meeting to order? Good afternoon, everyone. I think if you allow me, I wish to resume our session today. And for today, we are going to deal with the remaining items. There are two agenda items. Item 39 on consolidated statement of continuing ICAO policies in the legal field, and item 40, the other issues to be considered by the Legal Commission. And now I'm going to directly go to agenda item 39. On my list, there will be 4 working papers, if I'm not mistaken, yeah? Working papers number 9 on consolidated of continuing ICAO policies in the legal field, and working paper 204 on civil aviation legal advisor forums, and working papers 236 on credit administration in civil aviation of China, working paper 335 on progress with regard to the promotion of the protocol to amend the Convention on the Offense and certain other acts committed on board aircraft, or Montreal Protocol 2014. Under this agenda item, there will be 2 information papers. Document number 142 on national no-fly list for onboard unruly passengers behavior by India, and working paper 534 on result of labor survey of disrupted passengers and staff preparedness and concern. As we did yesterday, I'm suggesting that for information, we are not going to have a discussion. This meeting just took note of the 2 information papers. If you allow me, now we go to the first discussion on working paper number 9. And now I have Mr. Andrew Opolot to present the paper. You have the floor, sir.
Thank you, Mr. Chairman, and good afternoon, everyone. Assembly Working Paper A40 P9, Consolidated Statement of Continuing ICAO Policies in the Legal Field, has been prepared mainly to reflect the work completed by the Task Force on Legal Aspects of Unruly Passengers, to update Circular 288 following the adoption of the Montreal Protocol of 2014, which amends the Torture Convention of 1963. Just to note, we informally refer to the Montreal Protocol of 2014 as MP14. As at the opening of this assembly, 21 states have deposited instruments to become parties to this protocol, which means that only 1 more party is needed to bring it into force. The completion of the task force's work, which started in 2015, was reported to the 37th session of the Legal Committee in September 2018. The committee accepted the recommendation of the task force that the updated guidance material be published in the form of a manual, as did the Council in November 2018. Accordingly, the manual on the legal aspects of unruly and disruptive passengers has now been published as ICAO document 10117. Through you, Mr. Chairman, I wish to acknowledge the presence here at this commission of some members of the task force on unruly and disruptive passengers that delivered this manual. Mr. John Thatchett, representing Canada at the time, served as the chairperson of the task force. Ms. Yue Tan of Singapore, Mr. Michael Jennison, and Ms. Linda Ubokdom of the United States, Mr. Matti Tupamaki of Finland, Mr. Terry Olson of France, who joined us occasionally in his capacity as chair of the legal committee, and Mr. Tim Cole Han and August Hawking of IATA. IATA incidentally hosted 2 meetings of the task force in Geneva, and they, together with IFALPA, the Airline Pilots Association, are valued industry partners in this work. The working paper also highlights the status of ratification of the protocols introducing Article 3 bis and 83 bis of the Chicago Convention, with 156 and 176 state parties, respectively. Accordingly, the text in Appendix C of the resolution needs to be updated in light of the substantial number of states that are now party to these instruments. The working paper also reports on the introduction of the ICAO International Air Law course in 2017 under the Train Air Plus program. The course has the objective to enable personnel of civil aviation administrations, airports, and air navigation service providers of member states to support their organizations in the implementation of air law. Associated text is added in the preamble clauses of Appendix D of the resolution. And for further information of the delegates, this course, originally delivered in English only, has now been translated into French and Spanish. Flyers for the upcoming deliveries of this course in 2019 and 2020 were deposited at your desks yesterday. With regard to Appendix F of the draft resolution, this item has over the past decade undergone some evolution in the title of the work, which was originally referring to CNS ATM systems. Yesterday, this commission decided once again to reformulate this title. So the first operative clause in Appendix F needs to be updated to reflect the current title and priority of the item in the work program of the legal committee. The proposed changes to the Assembly resolution are marked up in the attachment to the draft Assembly working paper. Appendix E, in particular, is updated to reflect the publication of Doc 10117 and the consequential changes to the model legislation on offenses and acts committed on board aircraft. And if you will, Mr. Chairman, I would like to summarize what the key changes are about. One, to urge states to take into account the material in Doc 10117, including civil and administrative sanctions, in the course of developing their legislation and carrying out their enforcement tasks. This is in line with Article 15 bis of MP 14. Two, the terminology in Section 1 of the model legislation relating to the description of certain acts and offenses regarding assault, intimidation, and interference with crew duties is aligned as well to paragraph 1 of Article 15 bis in MP 14. The changes in Section 3 of the model legislation, where the words "in relation to smoking" in a manner likely to endanger the safety of aircraft are deleted and replaced with the words "when such act is prohibited." This change is made in recognition of the situation that other concerns such as health and air quality or the environment may need to be addressed by states in imposing restrictions on smoking. And we also did this to align with the wording relating to the treatment of portable electronic devices in paragraph 3 of the same section. It might be instructive in regard to this matter to consider that smoking on aircraft may not just be a safety issue, and therefore to recall Assembly Resolution 829-5, in which the ICAO Assembly, while noting the WHO's recommendation to ban smoking in public conveyances, where protection against involuntary exposure to tobacco smoke cannot be ensured, requested the Council, with the assistance and cooperation of the WHO, to take appropriate measures to promote a smoke-free travel environment on all international flights, and for states to take necessary measures to restrict smoking on international passenger flights. Fourthly, in Section 4 of the model legislation, the provisions on jurisdiction are deleted entirely, and this is in light of the broader provision on jurisdiction that are now contained in Article 3 of the Tokyo Convention as updated by, as modified by MP 14. Finally, with regard to the proposed changes, you will note that the word civil is deleted to align with modern usage, to align with modern usage and terminologies when referring to aircraft. And this is the case in treaties and across ICAO documents. However, it is to be noted that it remains the case, in spite of this modification, that the model legislation is not intended to apply to state aircraft, which is in line as well with the paragraph 4 of Article 1 of the Tokyo Convention. A final note before I conclude, Mr. Chairman, I wish to mention in relation to questions that have arisen about the status of Circular 288 following the publication of Doc 10117. Circular 288 has not been discontinued and remains available for some states, particularly those that do not become party to MP 14, that may find it to be still of use. That said, however, there should be no difficulty even for non-state parties to MP 14 to take into account the guidance provided in the new manual. Mr. Chairman, the Legal Commission is invited to approve the text of the resolution appended to the working paper for adoption by the plenary. Thank you, Mr. Chair.
Thank you, Andrew. We know that this paper essentially proposes to amend Assembly Resolution A3911 in order to reflect the work completed by the task force on legal aspect of unruly passengers to update Circular 288. And all the amendment has been clearly elaborated by Andrew. And now the Assembly is invited to adopt the amended resolution as appear in the attachment of the paper. Distinguished colleagues, I would like now to invite any delegation who wish to take the floor to give a comment or anything. The floor is open now. On my screen, the first speaker will be Eritrea. Yeah, I give the floor now to Germany.
Thanks a lot, Chair. I just have a question for clarification. Why is the word civil deleted in the paper? Is it because of the application of the convention, or what is the background of this? Thank you.
Thank you, Germany. I think I will let Andrew to respond this question.
Right away.
Thank you.
Right away.
Yeah.
Thank you, Mr. Chairman. The word civil is deleted, not with the intention in any way of changing the scope under the subject, but simply to align with the modern practice. We no longer need to add the word civil when we're referring to aircraft. And this is the language that is adopted in the ICAO treaties, including the Montreal Protocol 2014. And so I think the thing to emphasize is that aircraft is in the domain of civil aviation is commonly understood to mean to exclude state aircraft in its application. So it doesn't change the status quo. We're simply updating the language as mandated by the Council and the Assembly. Thank you.
Thank you, Andrew, for your clarification. Now I have Finland. You have the floor.
Thank you very much. Finland would like to support and accept this working paper and the resolution as it stands now. Very shortly, we are very much in favor of these amendments concerning especially this new manual. Thank you.
Thank you, Finland, for your very constructive ideas. Now I give the floor to Lebanon.
شكرا سيد الرئيس. أود
Thank you. I would like to thank the task force for their efforts. Their hard work has allowed us to arrive at this new work on legal aspects of unruly passengers. This includes an updated list of offenses committed on board aircrafts on the part of unruly passengers. We have, therefore, a new manual that replaces Circular 288. And it gives necessary clarity. And I would like to thank the task force and the Secretariat for all of the work carried out to publish the manual in the official languages of the organization prior to this assembly session. There is no doubt that the manual will assist member states to draft legislation and put in place the MP14, and thanks to this model legislation that is included in the working paper, national legislation will be consistent with the provisions of the protocol. And as to the content of this model legislation in Appendix E, and with a comparison with that which was in the version preceding this, that is the Resolution 839/11, Part 4 was struck out, that addresses jurisdiction. This deletion is consistent with the text of the model legislation in the new manual, and this in comparison with the former Circular 288. This model legislation does not have a chapter on jurisdiction. Nonetheless, the manual in its Chapter 4 does have a detailed explanation of those issues that tie in with jurisdiction. Mr. Chairman, can you explain why? What are the arguments taken into account by the task force which led it to not include the section on jurisdiction amongst the provisions in this model legislation? Because the harmonization of text on jurisdiction and the harmonization with national legislation is necessary and essential in our opinion. Thank you.
Thank you, Lebanon. Now I'm going to call Russian Federation.
Thank you, Chair. And thank you to the Secretariat for this document, this paper. We support the draft resolution in the form in which it is presented in Working Paper 9. And the high level of ratification by the states of the 2014 protocol and a whole series of working documents on unruly passengers, which has been presented here at this commission, shows that this is a relevant issue. And it shows that the states are deeply interested in this issue. I would also like to thank the elaborators of document 10117. This is an elegant resolution for a circular 288. We are happy to see how effective the work of the commission is, the legal commission. And we would like to mention the addition of B to the resolution, the draft resolution. It envisages that any draft of the convention that the legal committee sees as being prepared to be presented as a final draft is then passed on to the council. This text is what we have now and is not going to be changed right now. We would like to draw your attention to the fact that at in other areas of this assembly, information is being heard about drawing up international agreements that are to be adopted or reviewed in ICAO. We can make reference to 172, working paper 182, on developing an international convention on foreign investments in airlines. This is a document that belongs to the Economic Commission. The second document, 192, on reviewing or promoting the Air Transport Agreement of 1944. We presume that it would be more effective and a more orderly way of working on this. We believe that the legal commission should review the idea of working on these documents in the framework of its mandate. Thank you very much.
Thank you, Razia, for your comment. I think there are some matters that need to be clarified or to be responded by Secretariat. So I'm now going to give the floor to the Secretariat. You have the floor.
谢谢主席先生。
Thank you, Mr. Chairman. I'm very pleased that the Russian delegate I'm very delighted that the Russian delegate has very clearly mentioned certain working papers and the legal issues that they contain. This is how I see it.
Everything that require ICAO as a sponsor or adopted under the ICAO auspices, there is a procedure to go through legal committee first, working on the detailed treaties. Then when legal committee works on a treaty, it will report to the legal commission through the secretariat, the work progress of the legal committee. On the other hand, it depends on the intention of the working paper's authors. Sometimes they may not mean to adopt these conventions or other form of treaties under ICAO auspices. 193 states are still free to adopt their own multilateral convention or treaties outside the auspices of ICAO. So in that case, it has not been referred to legal committee or legal commission of the assembly. If they really would like to have the treaties adopted under ICAO auspices, then we have special procedures that it has to go through the legal committee. Anything adopted by ICAO will go through the legal committee, especially when it's relating to the treaty amendments. I hope that clarifies the situation. Regarding the question raised by Lebanon, my understanding is, subject to Andrew's supplementation, because Montreal 2014 or Montreal 1.4 has already been providing the text of jurisdictions. So probably there won't be any need for the model law to talk about jurisdiction. It's automatically applied in the provisions, through the provision of the MP14. Maybe I missed something. I will leave Andrew to supplement. Andrew, you have the floor, with the permission of the chair. Thank you.
Thank you, Mr. Chair. Just to concur with the remarks just made by the director, indeed, the model legislation sort of fills the gaps that are in the treaty. For instance, as it wasn't possible at the diplomatic conference to agree on a list of offenses, so the task force was asked to elaborate that. So the best advice to share with the states would be that in considering their legislative and enforcement measures and framework, to look at the treaty MP14 alongside the material contained in the manual, as well as the resolution, which also elaborates what's contained in the manual, as well, including provisions on jurisdiction. Thank you, Mr. Chairman.
Thank you, Andrew and Mr. Chung, for your clarification. I hope the clarification can satisfy Lebanon and Russia. And I don't see any, on my screen I see United States. You have the floor.
Thank you, Mr. Chairman. I alluded yesterday to Montreal Protocol 2014 and offered I would give a little more clarification on why the United States objects to the ratification of this convention protocol. So I wanted to let everyone know, I know we've said this in previous assemblies and also during the diplomatic conference, but I wanted to make it clear for the new people in the room so there's no misunderstanding. The United States, of course, actively supports and encourages other states to take actions, both civil and administrative actions, to deter unruly and disruptive behavior on aircraft. As you heard, we were a member of the task force and contributed to the changes that were made to ICAO Circular 288, and that resulted in the published document 10117. However, the provisions in the Montreal Protocol 2014 that gave us serious concern were those that dealt with the in-flight security officers. In the US case, we call them federal air marshals. The protocol limited their authority to respond to threats on board aircraft as compared to the authority that they have as passengers under the Tokyo Convention. And as we talk about jurisdictional issues, you'll recall that Tokyo, the Hague Convention, and the Montreal Sabotage Convention all provided jurisdictional bases to take the actions on criminal issues, for sure. So with regard to the protocol's attempt to address the jurisdictional issues raised by a few states that resulted in language that makes implementation of the state of landing jurisdiction over offenders difficult for many states. For these and other reasons, the U.S. was disappointed in the protocol, and the U.S. government agencies represented at the diplomatic conference recommended that the U.S. government not sign or accede to the protocol. We've also published a question and answer paper that helps further address these issues, and I'm happy to speak with anyone at the Commission here further. Thank you, Mr. Chairman.
Thank you, U.S., for your clarification. On my screen, I have Singapore. You have the floor.
Thank you very much, Mr. Chairman. First, I'd like to thank the Secretariat for this working paper and to say that we support the amendments to update the resolution. This was in line with the resolution of the Diplomatic Conference in 2014, and it's really good to see that the work has been completed. And the amendment of the resolution will complete the work. Just a small point to ask. In Appendix E on page A4, the last sentence, it says calls on all the contracting states to submit to their competent authorities for consideration of prosecution or application of administrative or any other forms of legal proceedings. This is, of course, to align with the Montreal Protocol 2014, but I wonder whether we could change application to use, because normally we don't talk about application of forms of proceedings. So just a small edit to improve on the wording. Then if you will allow me, I just want to make one point regarding this work, that the legal committee exists, in my opinion, to serve the organization and states. And I think that this work by one of the groups that came out of the diplomatic conference, in which the legal committee encourages, is an action taken to serve the international community. And I just would like to highlight this point. Thank you very much.
Thank you, Singapore. Now I would like to give the floor to Palestine.
Microphone. Microphone to the speaker, please.
No. So somebody else, I think. Okay, so I just want to give the floor to any other delegation who is to make any comment. Okay, thank you. There are two more speakers on my screens. First is Ghana and China. Ghana, you have the floor.
Thank you very much, Mr. Chairman. Since this is the first time Ghana is taking the floor, we want to congratulate you on your appointment. Mr. Chair, Ghana wants to say that we support the paper submitted by the Secretariat. First and foremost, we want to applaud the work of the task force, which has helped us tremendously in aligning the work and then enhancing the work, especially in respect to the MP 14, to help us in coming up with a better model legislation, which will enhance the work of states in ensuring that we are able to domesticate issues to do with unruly passengers, etc. We further want to support the resolution requesting for the expansion of the teaching of air law in those states or regions in which it's not yet available. Mr. Chair, Ghana therefore supports the paper as submitted. Thank you.
Thank you, Ghana. China, you have the floor.
Thank you, Mr. Chairman. The Chinese delegation supports this working paper, and we also we very much appreciate the outstanding work done by the task force, especially Appendix E about the unruly passengers and integration with paper 188. We think this was very necessary because as the aviation industry develops so quickly, and for instance, China's domestic and international aviation is developing very quick, there are increasing numbers of unruly or disruptive passengers, which also threaten aviation safety. And the Chinese government is also taking proactive measures with a legal basis, using credit and other punitive methods to manage these unruly passengers. So the Chinese delegation fully supports this Working Paper 9. Thank you.
On my screen, I see the name of Palestine reappear. I just want to make sure anyone press Palestine. Okay, I don't see anyone. So, distinguished delegates, I think, yes, Palestine. You have
sorry. It was IATA as actually on the screen, being disguised as a state.
Okay, sorry, IATA, you have the floor.
Thank you very much, Mr. Chairman. IATA has noted with interest the remarks of the United States just now on Montreal Protocol 2014, which indeed are broadly consistent with the position of the United States at the diplomatic conference to adopt the protocol in 2014 and subsequently. IATA believes that there are substantial benefits to be derived from a broad ratification of MP14 by the international community and from its earliest possible entry into force. Consistent with the protocol and ICAO manual on the legal aspects of unruly and disruptive passengers, as referred to in Working Paper 78, the way forward for an effective legal framework on unruly and disruptive behavior on board aircraft is clear. We've analyzed the arguments put forward by the United States, and we do not believe these arguments to be of broad application to other states. These arguments tend to reflect the specifics of the United States system of in-flight security officers, IFSOs, or federal air marshals in U.S. parlance. IATA believes that concerns in respect of IFSOs can be resolved. IATA does not believe that MP14 represents a real or substantive restriction on the freedom of action by any state on security matters in respect of aircraft. We appreciate and we recognize the leadership of the United States in this area over a great number of years with its special aircraft jurisdiction. Other states have also taken their own national law measures prior to the diplomatic conference of 2014 in response to the well-known jurisdictional gaps of the Tokyo Convention of 1963. The special aircraft jurisdiction and other similar national law measures in other states do represent a solution of sorts at the individual state level. But the problem that motivated the protocol is a broader one. It requires a legal framework at both ends of a route. It therefore requires action by the international community in respect of all states to introduce a state of landing jurisdiction in the interest of promoting global uniformity. Thank you, Mr. Chairman.
Thank you, IATA, for your observation. Now, I want to give the floor to France.
Merci beaucoup.
Thank you, Chair. The French delegation supports WP9 naturally and associates itself with the comments made by a number of delegations to congratulate you on the quality of the work that led to this manual. And I would also like to do it here today as the delegate of France, but also as the former chair of the legal committee. It was at the last session, which I had the honor of presiding, that we heard of the remarkable work that had been done. This delegation would also like to indicate that it shares the observations made by IATA to a great degree. The MP14 is perhaps not perfect and satisfactory in all aspects, but it is meritable and certainly reflects air law. I would also like to say that the French authorities have launched the process that I believe in several months will lead to the fact that the Parliament will have studied the draft for ratification. And if the bill is approved, then we can hope that the instrument of ratification could be deposed within the next few months. Thank you. Pardon me, in 2020.
Thank you, Franz, for your intervention. I don't see any more speakers on my screen. So I think I can assume that this paper enjoy support from all delegation. So if you allow me, I suggest that the Legal Commission recommend that the proposed amendment to the resolution in this paper forwarded to the plenary for adoption. And of course, we also took note some the small improvement as suggested by Singapore. I think it will be reflected on the new revised draft of the resolution. If there is any objection, I'm proposing that we can move forward to the next agenda item. I see Lebanon.
Merci, Monsieur le Président. À la suite.
Thank you, Chair. After hearing the clarifications from the Secretary, Lebanon fully supports the working paper and the draft of the resolution attached to it. I would, however, like to make several corrections to the French text of the resolution on page A3. The date of the authentic text in 6 languages of the Chicago Convention is the reference. And the date is 1995 and not 45. It's correct in English and it's correct in Arabic, but the correction needs to be made in the French text only. On page A4, in this appendix, which is in gray and begins with the following phrase: other than the publication of the document by ICAO, one would think that the phrase is incomplete. And it is, in fact, sufficient exactly as it is. The only problem is that the one word needs to be removed. Cool. Thank you.
Thank you, Lebanon, for your constructive proposals. I just want to consult with the Secretariat. Is okay?
We will consult with our language branch to rectify the relevant portions of the French text. Thank you.
Thank you, Dr. Huang, for your clarification. I think we can move forward to the next agenda item. So we are going to forward this paper to the Assembly, of course, with some small improvement as proposed by Singapore and text of the French revision of the French text as proposed by Lebanon. So the next paper that we are going to discuss is working paper 204 on civil aviation legal advisor forums, and now I'm going to invite our colleague from Singapore to present the paper. You have the floor.
Mr. Chairman, first, I would like to inform that this working paper 204 on the inaugural Civil Aviation Advisors Legal Forum has the following additional co-sponsors: Belgium, Indonesia, Nigeria, Philippines, Russian Federation, South Africa, and the United Arab Emirates. Thank you very much to all the co-sponsors of this paper. We wish to thank ICAO and in particular the Legal and External Affairs Bureau, for the opportunity to host the inaugural edition of the forum in Singapore in May 2019. It was a great pleasure to work with the Legal Bureau, and in particular with their colleagues there, especially Andrew Apolot, to organize the forum, and it was altogether a happy event. Sections 1 and 2 of the working paper provide information on the forum, which we call, in short, CALEF. It was attended by more than 80 legal advisors from 40 states and 1 regional organization. At this juncture, please allow me to thank all states whose legal advisors attended, without whose presence and active participation, we would not have had such a useful and very happy CALEF. There were others who wished to attend, but were not able to for various reasons. For them and for all interested, we'd like to inform that an electronic publication setting out the proceedings of the inaugural CALEF is available on the ICAO website at the URL link set out in paragraph 2.3 of the working paper. Through the CALEF, we recognize, but more importantly, we want to assist legal advisors in their support of their states and organizations to implement air law treaties, including the SAPs, and to formulate and update national laws and regulations to give effect to national policies and regulatory requirements. In addition to legal seminars and workshops and other similar events, the regular convening of the CALEF can enable legal advisors to continuously update and enhance their competencies, capabilities, and capacities to carry out their responsibilities effectively. We strongly believe and encourage ICAO and states to harness the support of their legal advisors to strengthen and enhance their capabilities to respond to new and emerging opportunities and challenges, as well as threats to the safe and efficient development of international civil aviation. Accordingly, we would like to request this Commission to invite the Assembly to adopt the proposed Assembly resolution set out in the appendix to the working paper. As you will see in the appendix, the proposed resolution takes into account the views and plans that came out of the inaugural CALEF. I would highlight that the proposed resolution seeks to promote the establishment of positions of dedicated in-house legal advisors for civil aviation administrations, promote the use of ICAO seminars and workshops, the International Air Law course, and other similar events for the continuous training and development of their legal advisors, and invite support for the CALEF initiative. States are encouraged to consider hosting subsequent editions of the CALEF and to encourage and facilitate their legal advisors to participate in and to contribute to the CALEF. I'm happy to share that a couple of states have already indicated their interest to host a future edition. The resolution also encourages states to consider hosting seminars, workshops, the International Air Law course, and similar events in their states and regions. Further, the proposed resolution requests the Secretary General to assist member states in achieving and maintaining the appropriate competency of civil aviation legal advisors, including through developing a competency framework for strengthening their role. It also invites member states to support ICAO's work in the legal field by encouraging the active participation of their legal advisors in the work of the legal committee, subcommittees, and task force, panels, working groups, not to mention the legal commission, of course, and similar bodies established to examine air law issues and develop legal solutions for the international civil aviation community. The working paper and the proposed resolution in the appendix is for this Commission's consideration. Thank you very much, Mr. Chairman.
Thank you, Singapore, for presenting your paper, which essentially inviting the Assembly to adopt a proposed Assembly resolution on topic enhancing the capacity and effectiveness of the states to implement air law treaties and update national laws and regulation. Before I proceed, I wish to invite delegation who would like to make a comment. And on my list, I see some speakers, of course. For the first one, I wish to give the floor to Saudi Arabia.
Thank you, Mr. Chairman. We would like to thank Singapore for the paper presented, as well as the countries that have sponsored this paper. And we wish you a great success for CALAF and any similar events. Thank you, Mr. Chair.
Thank you, Saudi Arabia. Israel, you have the floor.
Thank you, sir. Israel want to support the document and the resolution proposed. We want to thank Singapore CAA and the Academy and the Legal and Foreign Affairs Bureau in ICAO for organizing the very successful event, to our opinion. And also we strongly we feel very strongly about in-house legal advisor capability in the CAAs in a very important way to fulfill aviation policies. Thank you.
Thank you, Israel. Now I'm calling Gambia.
Thank you very much, Mr. Chair. Gambia is proud to associate itself with the working paper as a co-sponsor. Gambia fully supports the working paper and the association resolution to the annex to the paper. As a participant at the forum, I would like to assure the Commission that this was a truly remarkable event at which interesting and relevant topics were covered by a diverse range of participants from all over the globe. We cherish the opportunity to be exposed to the different views and experience the event during the event. The event was remarkably successful in terms of content, participation, and the fabulous arrangement and hospitality by the ICAO Legal Bureau and the host state, Singapore. And Gambia wishes to call upon for the host of the event to emulate the standard set in the inaugural session. And with the introduction of this forum, together with the implementation of the draft resolution, we expect to see the strengthening of the legal capacity of legal advisors to support their organization in the implementation of the ICAO Treaty and recommended standards. As we are all talking about legal forum, Gambia is happy to actively contribute to the promotion of air law. And in this respect, we're pleased to announce that Gambia will be hosting an air law course and an air law seminar in February. The air law course is scheduled from the 17th to the 21st of February, and subsequently the seminar will take over from the 24th to the 25th of February 2020. And we would like to take this opportunity to thank the Secretary General for authorizing the ICAO Legal Bureau to host this event in the Gambia. We look forward to welcoming everyone to the Smiling Coast of Africa in February 2020. Thank you.
Thank you, Gambia. Now I recognize North Macedonia.
Thank you, Mr. Chair. Republic of North Macedonia would like to fully support Working Paper 204. We attended and benefited from this first CALAF that we find it very extremely useful. CALAF could and should become an excellent forum not only to discuss but also to share experience and best practices, as well as to advance the solutions regarding the legal issues in the aviation sector. Thank you very much.
Thank you, North Macedonia. Finland, you have the floor.
Thank you, Chair. As co-sponsor of the paper, I can do nothing else but support the paper. And like you heard from many eminent colleagues around the room, it was indeed a very remarkable event. For us lawyers, it represented a new format for having international discussions on a subject very dear to us, and provided the possibility of exchanging ideas and discussing matters that are very of interest, but of particular interest to us right now. It was very inspirational, it was very informal, and I think that as such a format very well complements the other legal gatherings we have created in the on several international fora. Thank you again for Singapore for hosting the marvelous event, and thank you also for the ICAO Secretariat for being involved in the creation of this event. Thank you.
Thank you, Finland. Can we now go to Italy?
Thank you, Mr. Chair, and good afternoon, everyone. Italy supports the Working Paper 204 presented by Singapore and the adoption of the enclosed proposal resolution. Italy believes it is essential, in addition to training and continuous updating of civil aviation authority professionals who carry out consulting activities to their organization to the benefit of end users, to have the possibility to engage a direct dialogue on emerging issues and practical solutions among colleagues working with the different contexts and juridical systems. The legal advisor's activity is challenging, future and innovation-oriented, complex because of the shortage of ready-to-use references and consolidated case studies, so that it needs comparison and international approach. In order for the legal and technical sector of civil aviation to move forward at the same pace, Italy welcomes the Civil Aviation Legal Advisors Forum, which is different for purposes and objectives from other legal commission, committees and groups, and whose inaugural session as itself very successful and useful, as reported by participants, as an essential platform to enhance legal advisors' competency and speed up the effective implementation of air law instruments. Thank you.
Thank you, Italy. Now I'm going to invite Botswana.
Thank you, Chairperson. Being the first time that the delegation of Botswana takes the floor, we would like to congratulate you on your excellent work that you're doing in the Commission. As a co-sponsor of the working paper by Singapore, I would like to first and foremost commend Singapore and the work that was done by the Secretariat. This was a well-organized and effective forum for us as legal advisors. And the state of Botswana would like to encourage that this forum continues, and we would also like to support the recommendation that there should be a competency framework that is developed for legal advisors. This would greatly assist us in making sure that we are able to respond to the emerging issues in aviation. It would also assist in making sure that we are able to ensure consistency and uniformity of international law and the regulatory frameworks within our states. Thank you very much.
Thank you, Botswana. Now I would like to invite the United Kingdom.
Thank you, Mr. Chairman. The UK attended the inaugural Civil Aviation Legal Advisors Forum. It was a very valuable opportunity to meet legal colleagues from other member states and to share their views on current and upcoming legal issues. So the UK is very happy to support the proposed Assembly resolution. Thank you.
Thank you, UK. Can we now go to Oman?
شكرا سيد الرئيس. أود أن أشكر دولة سنغافورة ورقة المقدمة.
Thank you. I would like to give my thanks to Singapore for this working paper. Also, I would like to thank the representatives of Singapore that has just presented the paper and referred to all of the efforts made by members of the Secretariat in organizing this forum. The working paper was presented with emphasizing particular items. There was reference to civil aviation and the ties in with the legal framework, which unfortunately has not benefited from the required attention from national authorities for civil aviation in some states. So no doubt this working paper will be a very interesting initiative for the future. Thank you, Chair.
Thank you, Oman. Now I would like to invite Ukraine.
Thank you, Mr. Chairman. Ukraine would like to support working paper 204 presented by Singapore. So we are welcoming this Civil Aviation Legal Advisors Forum as an effective and efficient platform for sharing experience, continuous training and development of legal advisors. And we support the adoption of the proposed resolution. Thank you.
Thank you, Ukraine. Now I would like to invite United States.
Thank you, Mr. Chairman. And just to be brief, because we've heard all the great support for this effort, I was pleased to be a part of this inaugural event. Fully support the effort. I congratulate the Legal Bureau for taking the initiative to establish this forum, and thank Singapore for hosting the first forum. And I would say it's a benefit for all of us to come together in this type of environment and share our views. It gives us each a better understanding of where each of us is coming from as we discuss very timely issues. If you looked at the list of issues we were speaking about, very timely. The 737, we talked about German wings. We talked about a number of issues that concern us, and it's an opportunity I think we need to take advantage of. So fully support it, and it's a very good cause, and I thank you, Mr. Chairman.
Thank you, United States. Now, China.
Thank you, Mr. Chair. CAC, Chinese delegation. And we also support this working document. And also we participated in this inaugural forum. We support this working document, just like we jointly consigned. From the first forum, we can see that it is very necessary to have this regular forum in this contracting parties. A very significant approach is to safeguard the safety of international civil aviation. So this is our consensus. With this consensus, so technical problems can be easily solved. Legal issues may be sometimes constrained by the different legal systems. Therefore, it is in great need to have an opportunity so the legal counselors of different countries can have a joint framework and share experiences. From this first forum, to a great extent, we have hit this target, and we can broaden our common understanding. And we can understand the common ground for some decision making. And also, it's a good opportunity to promote the cooperation of the legal counselors among the countries. Thank you, Ms. Chair.
Thank you, China. Now I would like to invite Cuba.
Thank you very much, Chair. Cuba, first of all, would like to thank the Singapore representative for presenting this working paper, and Cuba supports entirely what is listed in the working paper as well as the resolution. We believe it is an interesting initiative, not only interesting but necessary. In all of the universities that the specialty is studied, but there are new generations of legal experts that could benefit from this kind of forum. Thank you very much.
Thank you, Cuba. Now I would like to invite Gabon.
Thank you very much, Chair. Good afternoon to you all. Gabon joins other delegations in fully supporting this working paper. small states such as Gabon will certainly benefit. It would be interesting to develop a mechanism that takes into account the financial reality of some of the member states such as ours, and that would favor the participation of some of the representatives. Perhaps certain expenses could be covered. Thank you very much, Chair.
Thank you, Gabon. The next speaker will be Australia. You have the floor.
Thank you, Mr. Chairman. As a co-sponsor of the paper and a participant in and hopefully a contributor to the success of the Caliph, I can only endorse everything that I've heard so far about what a remarkable and valuable exercise it was, and I'm sure it will continue to be. With respect to the resolution, I noticed the eminently practical rationale for the continuation and expansion of this program that we fully support, but something that's missing that I'd like to suggest be included, because I think it was both explicit and implicit in the kind of experience that we all had that was there, and that's making reference perhaps in the third preambular paragraph to, in addition to all of the other things that legal advisors can and should do within their authorities and in accordance with their role, is to assist their authorities in their adherence to the rule of law. It's a principle that the United Nations adopts. It's implicit also in much of what what ICAO does, and if I'm not mistaken, there's an imminent legal publication that refers to the importance of the rule of law in the achievement of aviation safety. So if there's some way that recognition of that aspect of the role of a legal advisor and a regulatory authority could be included in the resolution, I think that would be a positive thing. Thank you, Mr. Chairman.
Thank you, Australia, for your constructive proposal. Can we now go to Netherlands?
Thank you, Mr. Chair. The Netherlands would like to join the former speakers in supporting the initiative of the Civil Aviation Legal Advisors Forum. Cooperation amongst the legal advisors certainly is essential in enhancing the legal aviation framework. So thank you.
Thank you, Netherlands. Lebanon, you have the floor.
شكرا سيد الرئيس. لبنان يؤيد
Thank you, Chairman. Lebanon also lends its support to Working Paper 204. We believe that the Caliph held in Singapore was very important. This forum should be held before international conferences, for instance, or meetings of the Legal Commission. Holding such a forum would be very helpful for exchanging information between legal advisors. Thank you.
Thank you, Lebanon. I think after having very long list of speakers, I hope there is the last speaker would be France.
Thank you very much, Chairman. The delegation of France supports Working Paper 204. France was not able to attend the inaugural forum for essentially practical reasons, but all of the feedback we heard before, during, and after were excellent, and we want to warmly thank the director, Mr. Huang, of the Legal Commission, and especially Madame Tang. We truly believe that this type of forum should have its place, but we should keep in mind that the forum will not have its full meaning in the legal landscape of ICAO unless this forum, which is for an exchange of expertise and information, is placed in the hierarchy of decision-making, the Legal Commission for Assembly and the Legal Commission. And concretely, in our view, it would mean that if the forum is to debate current and topical issues, the Legal Committee would need to be able to meet every 2 or 3 years. And just as the delegate of Lebanon said, these forum meetings could serve to prepare for other meetings, but would need to be able to work taking into account all of the progress being made in the legal work at the heart of the legal committee. So this legal advisors forum is excellent, and we support it without any reservations. But we think it's important to develop the legal activity in ICAO through its different bodies. Thank you, Chair.
Thank you, France. Now I have Canada.
Thank you, Mr. Chairman. As a co-sponsor of this paper, Canada fully supports Working Paper 204 in the CALAF and would like to thank the Singapore representative for presenting this working paper. Canada also wishes to encourage all member states that have not already done so to establish civil aviation legal advisors and air law practitioner positions in their effectives in order to support their civil aviation administrations. Thank you.
Thank you, Canada. I still have Guinea.
Merci, Monsieur le Président.
Thank you very much, Chair, and good afternoon to everyone. The delegation of Guinea would like to strongly support this working paper, given that legal issues are at the heart of the concerns and the work of ICAO. So the Legal Advisors Forum is fully supported by the delegation of Guinea. Nonetheless, we would like efforts to be made to foster the maximum participation of legal advisors at the forums. And there is going to need to be an effort made to make it possible in terms of even language accessible to all. There are discussions underway to see to it that the work is actually carried out in all of ICAO's languages. But seeing as legal matters are sensitive, everything that is said needs to be understood fully by all. That is the only way for the work of this forum to be harmonious. Therefore, when these fora are held, every effort should be made to enable full participation. Even if you participate at the forum but cannot communicate properly, then it's going to be very difficult to follow. So this is an appeal from the delegation of Guinea. We would like to be able to participate fully and effectively in this type of forum. Thank you.
Thank you, Guinea. Now I have South Africa and Ghana.
Thank you, Chair. South Africa, as a co-sponsor and a participant at the event, would like to congratulate Singapore and the Legal Bureau for a successful event and therefore support the paper, and also wish to support the recommendation in regard to the establishment of a database for sharing of information, and also echo France's sentiments around the alignment of the work of the forum with that of the ICAO Legal Commission. Thank you.
Thank you, South Africa. The last speaker may be Ghana.
Thank you, Mr. Chair. Ghana would like to congratulate the ICAO Legal Bureau and Singapore for this first CALAF meeting, which you can all tell was really tremendously successful. Would like to encourage 3 areas. First, the institution of additional training for legal advisors, in addition to the International Air Law course, which is currently undertaken by ICAO. Would further like to encourage the participation of more legal advisors in the various legal committee meetings and other regional block meetings for lawyers in general. Finally, would also like to encourage the creation of an in-house legal directorate in the various civil aviation organizations, as it came to light that quite a number of civil aviation organizations had to fall on the expertise of the Ministry of Justice and Attorney General. Ghana fully supports this paper. Thank you.
Thank you, Ghana. I see no more speakers on my screen. I think we are arriving at the end of our deliberation on this working paper. It is my conclusion that there is a great support from all of us to this working paper, and we also took note some positive comment and proposal, particularly for improving how the Civil Aviation Legal Advisor Forum should be carried out. So if there is no more comment, I wish to suggest that we can pass this draft resolution and this working paper with the draft resolution to the Assembly. Of course, the draft will also include minor improvement as suggested by Australian delegation. If there is no more comment, I think we can moving to the next agenda item. Okay, I'm glad that we can moving, and yes, Dr. Huang, you have the floor.
Thank you, Mr. Chair, and thank you for proposing to forward the draft Assembly resolution to the plenary. I would like to make a few remarks concerning the Civil Aviation Legal Advisor. As the head of ICAO Legal Department, I personally take it as my mandate to promote that. Of course, I understand that different countries have a different systems. I respect. Some of them work under Attorney Chamber, some of them work under Department of Justice, some of them work under Foreign Affairs. That's perfectly normal. But I would take this opportunity to encourage all states, members of the ICAO, that no matter who, you should have at least one legal advisor that would be having responsibility for civil aviation legal matters. I'm aiming for that, and I count on you to support that idea. Thank you.
Thank you, Mr. Wang, for your highlight. I think we can go to the next other working papers. If I must suggest you know that our time is very limited because of the previous paper. Sorry?
We need a coffee break, probably.
Okay, so I think I received very wise suggestion that we should take a break for how long? For 10 minutes. So the meeting is adjourned for a while. Can I call the meeting to order?
Hello. Oh, you finally show up.
How are you?
China is not there.
Sorry.
China is not there.
Thank you, ladies and gentlemen. Under this agenda item, we still have two more working papers. And before we continue our business today, I was told by a colleague that my colleague from Singapore would like to say a few words. Singapore, you have the floor.
Microphone.
Microphone, please.
Microphone for Singapore.
Problem with my microphone. Oh, okay, good. Thank you, Mr. Chairman. And first of all, I would like to just say that among the co-sponsors is also Saudi Arabia, and I was remiss in not including in the list, and apologize to Saudi Arabia and wish to thank them very much for their co-sponsorship of the working paper as well. Thank you very much.
Thank you, Singapore, for your clarification. Now, I think we can continue our business. We still have two more working papers under this agenda item. Working paper number 236 on credit administration in civil aviation of China. And the other one is working paper 335 on progress with regard to promotion of the protocol to amend the Convention on Offense and certain other acts committed on board aircraft or Montreal Protocol of 2014. You know that our time is very limited today. I think we should stop our meeting today at 6 as usual. At 5, sorry, thank you so much for correcting me. I think we need to expedite our work, and for that purpose, I really appeal the delegation for China and the author of the working paper or 335 just to summarize the working papers and just to highlight it. So if you can present your working paper as brief as possible, so we can move faster. Now I just want to give the floor to China.
Mr. President, as you said just now, time is very tight, but I do have a small request. I would like to take the time allocated to number 235 to put it into this working paper 236, because the contents of 236 has a lot of content that many people may not be familiar with, but I will highlight the key points as quickly as possible. About our credit administration, I want to address this from three parts: the background, the contents, the legal basis, and remedies and transparency. So first of all, the background. When this CAAC, which is the civil aviation regulator, when we did this out of two considerations. First of all, it has to do with the specifics of aviation in China. The sector in China is developing very quickly. So in terms of safety management and the rapid development of market, too many people and entities are in hot pursuit of economic profits, and therefore dishonest behavior ensues. And China is a very large market, developing very quickly with people of very different calibers. resource development is slower than the actualities of the enterprises, so we have a lot of pressure on our oversight procedures. The second thing is that the passengers come from a very different backgrounds. Many of them are flying for the first time in their life, and therefore there's a lot that they don't know about flying. Many of them are inclined to overly be protective of their own rights, and therefore this is not good for the fact that flying happens at high speeds, at a high altitude, and in closed spaces. So in this early phase of our market development, there will be either conscious or non-conscious out-of-order behavior which must be regulated. So because of that, it's very necessary for China to have a system to manage these people to ensure the positive development of the market. After we go past this special phase, we plan to undertake assessments of our oversight measures. Now, the contents of this system, this credit system, this credit management is an entire system. It includes entities and people who are engaged in the aviation sector, and as well as passengers. And therefore, we have two blacklists. The first is the sector blacklist, and this is aimed mainly at entities or individuals engaged in the aviation sector who have seriously violated laws, and they are blacklisted for 1 year. And right now, we have an airport in Hebei province and a general aviation company in Guangdong who are on this entity blacklist. There are also 14 natural persons on this blacklist. Most of them are pilots or security personnel. And these 14 people are all Chinese nationals. There are no foreign nationals. Now, for the passenger blacklist, this is aimed mainly at passengers who are misbehaving in the aircraft cabin, at security procedures, or in the terminals. So if they commit one of 9 listed offenses and have been punished by the police, they are put on the blacklist, and within 1 year they are not allowed to buy air tickets. Also, for foreign flights which land in China with unruly passengers, we also exercise our jurisdiction and can put those people on our blacklist. And the CAAC, at the same time that these two blacklists are developed, we hope that this will help achieve some balance between service providers and the passengers and treat both the service providers and the consumers. And now, the third area I want to address has to do the legal basis, the remedy measures, and the transparency of our credit administration system. Our legal basis is Chinese domestic law and also the Chinese aviation regulations. And so right now, among the CAC regulations, we've added this credit requirements, and there it is spelled out which behaviors get people a place on the blacklist, and the rules have been revised accordingly. Secondly, we do have comprehensive legal remedy measures, which take place in 4 phases. The person in question, or the entity in question, has a right to be heard, to ask for a hearing. So if a passenger is blacklisted, you will first get an official written notification, and they have a right to appeal, a right to a hearing. In the second phase, they can ask for an administrative review. If they are blacklisted, they can use the Chinese Aviation Rule number 15 to ask the CAAC to review. The third stage, they can go to litigation. In other words, if they're not pleased with the result of the review, then based on the Chinese administrative law, they can go to court. And they can also go to court without going through the administrative review. The fourth phase is to the right to get compensation. If a law court, if they win in a law court, then based on the Chinese law of national compensation, they are entitled to be compensated. The third thing is about the question of transparency. All of these rules are put down on the CAAC website, and there's also an English version of the text. All the entities and individuals who are blacklisted are also listed on the CAAC website. And beginning in 2017, the CAAC has already conducted 10 rounds of training for Chinese entities and 4 rounds of training for foreign airlines to explain our credit system. And fourthly, in 2018, CAAC participated in ICAO's Asia Pacific Law Forum, the IATA annual meeting in Thailand, and also the ICAO, the Legal Council meeting in Singapore. And we described this credit system there. So what our hope is that through this work, we can further help more companies, aviation companies, understand this Chinese credit system. And that is why, because they know too little about it. We have been giving training to foreign airline representatives in China, but the high levels of their airline companies lack complete understanding of our laws, especially their legal departments. The other thing is that we hope that this system gets support from ICAO, because our practice has shown that this does effectively help to regulate the behavior of passengers and entities. It is an effective method. So to countries that are in the same stage of aviation development as China, we think it has good reference value. Thank you.
Recognize the intention of China to seek support from IQ to further improve the relevant works, and we also certainly really want to express our appreciation to your readiness to share information and to provide necessary help and necessary experience with other countries. I think this is a good thing that we can do in the future. Now, if you allow me, I just want to go to the next working paper before we have before I opening the floor for discussion. The next working paper is working paper number 335, prepared by IATA, IFALPA, and ITF. And I don't know who is going to present this paper. I believe IATA, perhaps? IATA, you have the floor.
Thank you, Mr. Chair. The unruly and disruptive behaviour of a small minority of passengers that includes physical assault, sexual harassment, damaging aircraft equipment, smoking and intoxication threatens safety and good order on board international flights. In many cases, those who commit such offences and acts during international flights do not face prosecution because the competent authorities in the state of landing do not have jurisdiction. Working paper 335, presented by IATA, the International Federation of Airline Pilots Association, and International Transport Workers Federation, explains how the Montreal Protocol 2014, or MP14, enhances the ability of states to deal with unruly passengers that are delivered to authorities upon landing in their territory, irrespective of the state in which the aircraft is registered. It also outlines the work that is being done to support ICAO in promoting ratification of this instrument. We congratulate the 21 states that have already become parties to MP14, but we respectfully urge all states to ratify MP14 so that there is a more robust international deterrent and so that we avoid a patchwork of national measures. Working paper 335 also highlights that there is often a reluctance to prosecute unruly and disruptive passengers, particularly for incidents that are not considered serious enough to warrant criminal proceedings. Again, this lack of enforcement undermines the deterrent aspect. States are respectfully urged to refer to the recently published ICAO document 10117, which gives expanded guidance on the potential use of civil and administrative penalties to complement criminal prosecutions. Working paper 335 concludes that with better prevention and stronger deterrent and enforcement, we can ensure an even safer and more enjoyable flight experience for all. Thank you, Mr. Chair.
Thank you, IATA. for your presentation. Now, I wish to open the floor for any delegation wishes to make any comment. I recognize South Africa.
Thank you, Chair. South Africa supports Working Paper 335 and wishes to announce to the Commission that South Africa has proudly signed the protocol on the 25th of September 2019.
Thank you. South Africa? And now I see Palestine again. Maybe IATA.
Thank you, Mr. Chairman. It is indeed IATA, disguised as Palestine. IATA has noted with great interest working paper number 236 on the system of social credit administration. IATA wishes to note that its members, as airline operators, have expressed concern in relation to the new social credit management system, particularly in respect to how social credit management would interact with the international regulatory framework for civil aviation. Of course, Mr. Chairman, it's well understood and nobody challenges that foreign air carriers have long been required to comply with the domestic laws of the countries to which they fly. But the application of this new type of national system, social credit administration, to foreign airline operators is unprecedented, and it's not presently clear as to how those sanctions, the sanctions prescribed under this system, would be reconciled with existing agreements and treaties in the field of civil aviation. This is a significant concern in IATA's judgment because the sanctions that may be applied would appear to include the effective denial or reduction of basic market access. That market access is typically attributable to the rights and obligations that are enshrined in bilateral air services agreements, rights that flow to the contracting states who have engaged in those agreements, and that the operators of civil aviation services rely upon in offering and conducting their flight operations. So as a result, IATA would be very grateful for clarification on this point. We really do not fully understand how it's going to be possible to take action on a foreign airline flying to China where that action ends up reducing or even denying the market access which is guaranteed under the bilateral agreement with that foreign airline's country. As a general proposition, furthermore, IATA would call for the highest degree of collaboration between governments on all national measures that impact upon the treaty rights of airline operators and, of course, upon the connectivity which those operators are providing to the world. Thank you, Mr. Chairman.
Thank you, IATA, for your observation. I see there is any delegation who wishes to take the floor. It means good news. We can, oh, yeah, I see France.
Thank you, Chair. France supports number 335 by IATA, and we have already put in place the ratification procedure of MP14. But as we've mixed into this discussion, this other working paper, so we have two working papers we're working on, I'd like to make an observation on working paper 236 presented by the People's Republic of China. France has attentively read the document presented by China and has listened very carefully to the observations from the delegate of that country. This delegation is wondering about the meaning and the extent of this action. If China is providing a mechanism for social credit that is completely domestic and meets the legal requirements and the cultural requirements of that country, then France will take note of it and will leave it at that. At the same time, we have difficulty understanding what the goal is of the presentation of this document to a multilateral body, which is what our commission is. Yet this is a purely domestic document, so we don't know how the commission could approve it or support it or criticize it conversely. However, if the objective of presenting this working paper is to promote this mechanism at the international level and to invite the member states of ICAO to use it as inspiration and perhaps to start thinking about it at a multilateral level, to use it as a basis for an international mechanism that would contain the same logic, France could then only express, if this interpretation is correct, express its doubts. In any event, the work of our organization is already too great to add something else, particularly as this new item is very complex, regards the principles of the culture, the fair culture that is applied in ICAO, and also touches upon airline agreements, as was just said by the IATA representative. So if the idea is to combat unruly passengers, then France would observe that ICAO is already dealing with this subject and has been doing so for several years. And in this respect, France could only express its confidence in the work already being done. And we do not see quite clearly how the mechanism presented in Working Paper 236 could be usefully integrated into that work. Thank you, Chair.
Thank you, France. Now I would like to invite Singapore.
Thank you very much, Mr. Chairman. First, let me address the paper by IATA and to express our support for the ratification of the Montreal Protocol 2014. I won't want to say too much about this because we have already spoken about it in the earlier discussion relating to the resolution. With regards to the paper by China, we welcome very much the extra information given by the representative of China in addition to the paper, and we note the various items that he had provided. And we think that in the spirit of understanding and collaboration and cooperation, the information that has been provided is most welcome. It is we know that we, as lawyers and as regulators, we are definitely concerned that passengers on board aircraft and the entities that operate in the civil aviation sector do the right thing so that we would achieve safety and security and order so that people can travel safely, businesses can be conducted in a regular and satisfactorily, orderly fashion. And it's very important, therefore, that we develop mechanisms and enforcement procedures and measures to encourage compliance. And where there is non-compliance, there is a need to develop, to use existing measures, whether it is administrative measures or whether it is criminal proceedings, to address them and to encourage good behavior. We have spoken in the work of the unruly passengers about the use of infringement notices, for example, to encourage people to comply. And so the development of new measures is, of course, interesting and worthy of exploration. And so we think that the proposal which has been given is something that is very useful for us to understand. There are, of course, understandably, because all of our systems would like to see that while we have enforcement measures, we would also like to see that the rights of individuals and of organizations when they undergo these processes are addressed. And the explanation that was given sought to cover that. So we welcome that very much, and we thank China for this paper. Thank you very much.
Thank you, Singapore. Now, I wish to invite Australia.
Thank you, Mr. Chairman. This is indeed a very interesting paper, and as interesting papers tend to do, it's raised perhaps more questions than provided answers. I note that the conclusion seeks support from ICAO to further improve relevant work, and perhaps this led to the uncertainty that the representative of France expressed. But I also look at the report of the 37th session of the Legal Committee, which considered an information paper presented on the same subject. And there, for reference, paragraph 217 under agenda item 2, it concluded by saying with reference to this particular paper, in addition to the expression of interest, the Secretariat indicated its intention to conduct a follow-up study. So perhaps I end with a question, and that is that was that follow-up study ever undertaken? And if not, is that perhaps the kind of further work that was sought, that is being sought in the conclusion of the paper before us today? Thank you, Mr. Chairman.
Thank you, Australia. Before I give the floor to Norway, I believe that... okay, Norway, you have the floor.
Thank you so much, Chairman. I'll be very brief in my intervention and say that Norway fully support the comments made by France.
Thank you, Norway. Dr. Huang, you have the floor.
Thank you, Mr. Chair. And thank you for the question raised by the delegation of Australia. You certainly have read the legal committee report very carefully. Yes, indeed, at the time when the paper was presented, there was an intention to further follow up this matter with a more detailed study. And we also had initiated, but not yet carried on, in-depth study on this matter. I noticed during this assembly, India also presented national no-fly list for onboard unruly passengers' behavior. So what our intention is, after the assembly, we would combine all these papers together and do probably a preliminary study, and then see where the direction will lead to. And if there is any suggestion, that the Secretary would refer back to whatever body that next meet, either legal committee or legal commission. Of course, I understand that China is also interested in collecting feedback from the international community on civil aviation, as they said, to improve the future system. Whether this system could be shared by others, of course, is a matter to be decided by its member states. But we can see already one kind of tendency that certain states started to develop this kind of no-fly list or other type of similar measure. So as a legal bureau of ICAO, I think it deserves us to notice these initiatives or national actions and see whether there is any implication in that. I hope I clarify the question of Australia. Thank you.
Thank you, Mr. Huang. I think I would like to give the floor to United Kingdom.
Thank you, Mr. Chairman. Regarding Working Paper 236, in line with comments made by France and Norway, which I can support, the United Kingdom also considers the paper raises many questions. The UK recognises the importance of member states having effective safety management systems in place to support the continuous improvement in aviation safety. However, on the basis of the information provided in the paper and today, the UK has concerns about the compatibility of this approach with different legal frameworks in other member states. And like France, it is unclear what action is being asked of ICAO. Thank you.
Thank you, United Kingdom. Now I would like to give the floor to IATA.
On the, so just a quick comment on the intervention of France, which seemed to be predicated on the assumption that this was a domestic-only system and that China was presenting it as a matter of information. That was at least a tentative conclusion. I should clarify that IATA reads the paper as providing information about a system that will apply to international aviation, to foreign operators. Foreign operators are indeed mentioned in the paper. And that is why we are seeking clarification of the way in which a system of this kind within China would be integrated into the international system, governed by bilateral agreements, by the Chicago Convention and annexes and SARPs and everything else. So I just wanted, if we are wrong about that, if it is a wholly domestic system with no application to foreign airlines, we would be grateful for that clarification. But that is certainly not how we have read the paper. China very graciously did appear, as the distinguished delegate from China told us, at the IATA Legal Symposium in Bangkok a couple of years ago, and spelled out quite clearly the social credit management system, giving us a very clear impression that it was indeed one that would cover both domestic and international operators of civil air services. Thank you, Mr. Chairman.
Thank you, IATA. Is there any other delegation who wishes to take the floor? China and then United States.
Mr. Chair, so China would like to reply the questions and the concern. First one, as to the question raised for IATA. So to whom does it apply to? So this application refers to, applies to international and domestic aircrafts as long as they land in Chinese airports, then they are within the scope of this system. And the second IATA concern is relation with bilateral treaties. According to our Article 184, this bilateral treaty has a higher status than domestic law. So, of course, we have the priority of this bilateral treaty, but usually it just defines the general policy on this aircraft arrangement. If the aircraft in China, they violated relevant laws, or they have the dishonest behaviors, then they cannot engage in that kind of behavior. But it does not mean that bilateral treaty is no longer effective. The third reply, so France, United Kingdom, and Norway representatives mentioned the directions or the actions we hope to have. We hope in international civil aviation community we can push forward this application of oversight in this by using this system. Just like what I have pointed out, a lot of countries in this kind of civil aviation development, from our experience, we feel that this credit management can help them to have effective applications. Of course, with the stabilization of such rapid development, we will evaluate our oversight system, because we will be confronted with the problems that we cannot keep up with the procedures. So how to balance the safety and order? We need to have innovation in our mechanism. Of course, I agree with the representatives of France and Norway. Whether to take such kind of actions will be decided by the contracting parties. So from our perspective, we hope that ICAO can recognize this exploration attempts of such kind of behaviors. Thank you.
Thank you, China. Now, I would like to give the floor to United States.
Thank you, Mr. Chairman. And I appreciate the discussion that we've had on Working Paper 236. I'd like to just say that this is all tied in to the discussion as well with regard to the earlier agenda item, working paper number 9. I appreciate all states have a duty and obligation to take necessary action against unruly passengers and illegal activities that may take place on board aircraft. And as we said earlier, we support those actions. Of course, I'm also required here to comment on Working Paper 335, which I previously commented on as it regards Working Paper 9, but since we took this as a separate item, again, I must say that for the reasons I laid out earlier, we object to Montreal Protocol 2014. But having said that, it's not with regard to the actions that we ask states to take with regard to unruly passengers. And we commend China for trying to address those activities. But with regard to Working Paper 236, as some of the other delegates have said, maybe there's some confusion with regard to what China's asking for. It was our understanding that they were trying to provide information and note for the Commission here the actions they're taking. But of course, it's not ICAO's job to give international legitimacy to any state's domestic law. I mean, all of us have different legal systems and take various actions for violations, and we recognize that and acknowledge that states have that prerogative. However, as it impacts international operations, then as a community, we probably need to look at that. And in that regard, I would suggest that maybe China will be able to give us more details about their program. This would be a perfect topic, in fact, for the legal forum, the one we had in Singapore, and maybe the next one in China then, to address this. I'd love to have a discussion about how their legal system addresses these issues. I mean, obviously questions about how you satisfy under your domestic law for what a dishonest act is, what an unruly passenger is, what type of conduct contributes to that, whether or not due process is set out the same way as it is in other states. All of these questions are pertinent to really resolve before you could have a final decision on whether we, adopt this application of China's system. So I suggest perhaps we can note the paper, and perhaps China will be willing to provide some additional material, and we can take further study as we meet again in our next legal committee meeting. Thank you.
Thank you, United States, for your proposal. Yes, I see Saudi Arabia.
Thank you, Mr. Chairman. I would like to thank the USA for the intervention regarding the point of view shared regarding the jurisdiction question. For example, if there is a judge who cognizes a certain incident, whether he would be bound by the domestic or national law or by the international law. In certain cases, we don't find solutions for certain gaps that we have in our practice. On another note, I would like to thank IATA for its intervention. In 2015, IATA, if I remember well, has adopted or has organized a workshop on this topic. I would like to suggest that we organize another workshop to study such different systems that are applied or implemented in different countries and how we can harmonize and how can we work within this environment. Thank you, Mr. Chairman.
Thank you, Saudi Arabia. Is there any other delegation who would like to take the floor? Germany, you have the floor.
Thanks a lot. We have an issue with the working paper 236 of China. I think it offers a principle how to punish people probably, and it's not concentrated on aviation especially. If you would like to follow this approach, then you have to discuss this on a basis. Germany has not such a culture, and well, I can't think of it that we would think about having it in the aviation sector solely, but probably, well, this is not a kind that we approach. Thank you.
Thank you, Germany. Is there any other delegation who would like to take the floor? I see none, so if you allow me, I would like to conclude on our discussion on working paper 236. I think we took note some questions and observations presented by various delegations to the paper. I think it is my understanding that this paper does not require any specific action by the Assembly. It's just sharing information from China. So if you can agree, I really want to take the proposal made by our colleague from the U.S., that maybe we can just took note the paper and welcome the information, and perhaps we can say something like additional information might be required for future deliberation, something like that. And for working paper 335 prepared by IATA, by IATA, NFALPA, and ITF, I think we just took note the working paper. I think because there is no much observation by delegation on this working paper. So if there is no any objection, we can proceed to the next agenda item. Distinguished delegates, before we are going to the agenda item 40, I just want to share with you, as I mentioned earlier, there are two information paper. Information paper 142 on national no-fly list for on-board unruly passenger behavior, prepared by India, and also working paper 534 on result of labor survey on disrupted passengers, staff preparedness and concern, prepared by ITF. I think as we did previously, we just take note of these two information papers. Ladies and gentlemen, now we're going to our business under agenda item 40. There are two working papers on my list. The first one is working paper 235 on targeted and precise oversight in the civil aviation industry of China. I think, China, you may have the floor.
Thank you, Mr. Chairman. I will just use a very, very brief time to tell you about this because the contents are already presented in the working paper. So the specifics are all there in great detail. I will just want to mention some of the background of this. CAC is adopting this targeted oversight is because of 4 considerations. The first is that our overall aviation is developing extremely quickly, and this has caused great discrepancies in different entity management levels. And so because of these great discrepancies, we are using data analysis to identify the areas of discrepancy. The second thing is that national resources for oversight are limited, and so some papers in the past have already ascertained that the development of our capacity for inspections, including the meeting that we had in August of this year, there was a general sentiment that in many countries the number of inspectors is increasing, is not nearly keeping pace with the development of the aviation sector's development. So we need to use some more modern methods such as remote oversight and other technology and so on. Then another thing is that the quality of inspectors is being affected by competition because of wages. So it's hard to maintain a caliber of inspectors. And again, we use data analysis to help to see how to keep the quality of inspection level. Third thing is that technology is developing very quickly, and that gives us ways to do more targeted oversight using IT and using communications technology and video technology. These opens many possibilities. And then fourthly, this lowers targeted oversight lowers its cost and therefore improves the competitiveness of the sector. And this not only lowers the cost of the regulators, it also lowers the compliance costs of the companies involved in the sector. Now, the specifics can be found in working papers, parts 2 and 3. And the actual results that we've seen from using it are in part 3 of the, and we hope that in the next phase we can get support from ICAO because our practice has shown that this is a very effective way of oversight, and it lowers costs and lowers compliance costs for the business entities, and it's also very valuable for as a reference. Thank you.
Would like to invite Aircraft Victim Families Federation International to present its working paper. You have the floor.
Sí, buenas tardes. Hablo.
Good afternoon. I am talking on behalf of the International Organization of Victims of Air Accidents and their families. We present this working paper 334 based on the different experiences experienced by victims with regard to the treatment given by different insurers to victims of air accidents. And we ask, with the approval of this working paper, that the delegates keep in mind the resolutions of ICAO and all of those involved in an air accident so that the best insurance practices are implemented to benefit victims, as well as exchange information through ICAO, and that access to this information be facilitated to international organizations, and that the USWAP system of ICAO provide the information so that delegates provide compliance reports for those who benefit from assistance. And under the UN, next year, a workshop or seminar be organized on best practices of states in the treatment within the territory of the air insurance. There are victims of the recent MAX aircraft accident, and the experience shows that there needs to be improvements both on the human side and the technical sides. Those who have lost family members or suffered any additional harm because of late actions taken by the insurers in regard to their organizations should be taken into account. And from the viewpoint of our federation, there needs to be exchange of best practices, and that will contribute to human and treatment of victims. Thank you.
Thank you. Now, I wish to give the floor to Spain.
Gracias, señor presidente.
Thank you very much, Chair. Spain agrees with the position of the Federation and what is expressed in Working Paper 334 and supports it. We believe in providing assistance to victims. We need to pay attention to how insurance companies implement what is in the Montreal Protocol. We think that it would be beneficial that states and international organizations share through ICAO their best practices in this regard, and that a seminar be organized to promote this. Thank you very much, Chair.
Thank you, Spain. Now, I would like to invite Argentina.
Muchas gracias, señor.
Thank you very much. My delegation would like to present the working paper presented by the International Federation of Victims of Air Accidents and their families. It is an issue that we are following very closely, and we would like to express our support to this working paper as well as the intervention just made by Spain. Thank you.
Thank you, Argentina. Now, I wish to invite Italy.
Thank you, Mr. Chair. Italy supports Working Paper 434 presented by Air Crash Victims Families Federation International. Of course, every plane crash, irrespective of whether due to safety or security reasons, is an unforeseen event to which the public is particularly sensitive in many respects. It is essential to ensure to victims and their families adequate material and psychological assistance, and that the compensation for those who are affected by the tragedy of an air crash is provided by insurances in the shortest time in compliance with the sector regulation. We agree with the proposal reminding to ICAO resolutions on the compensation of victims, insurers, and air operators. Moreover, we consider very important the exchange of best practices within ICAO on victims' treatment. And finally, we agree on the proposal of organizing a seminar on the treatment of insurances, air operators in member states. Thank you.
Thank you, Italy. Now, Portugal, you have the floor.
Thank you, Mr. Chairman. I would like to express my support to this working paper and to support the Spanish position. Thank you.
Thank you, Portugal. Now I'm calling Lebanon.
Thank you, Mr. Chairman. Lebanon supports the working paper provided by Air Crash Victims Families Federation International, as well as the intervention made by Spain that has clarified a number of issues related to this paper. I believe that this subject is extremely important, and it tackles the victim assistance regarding compensation of insurers. This issue is a matter that is at the top of priorities of the Executive Commission. 2 working papers were presented on the provision of air accidents victim assistance, 297 and 127. These are the working papers that were presented in the Executive Commission. However, this issue in particular is related to the compensation of insurers. The topic that was tackled by the Executive Commission is actually the facilities to be provided to the families of the victims. And therefore, I believe that the working paper presented to this legal commission is indeed extremely important and deserves due attention. Thank you, Mr. Chairman.
Thank you, Lebanon. Now, I wish to invite Mexico.
Thank you very much, Chair. Mexico would also like to support the working paper presented by the Air Crash Victims Families Federation International. Thank you very much.
Thank you, Mexico. Now, Finland.
Thank you, Chair. Finland would like to thank the author of this paper for a very good presentation and taking up a very important subject. Finland particularly would like to support action points A, B, and D of the paper. However, Finland has some reserves as to action point C, which refers to the USOAP program, Universal Safety Oversight Audit Program, as I believe the Council has issued some guidelines as to in which direction the program should be developed, concentrating on safety issues. So I warmly recommend all the other actions. However, I would recommend that the recommendation on the USO program could be looked at again. Thank you.
Thank you, Finland. Is there any other speaker? Yeah, Singapore.
Thank you, Mr. Chairman. We join in thanking the Air Crash Victims Family Federation International for their paper. In general, we definitely agree with the support that should be given to the victims of air crashes. It's the least that we can do. And I share the concern that Finland has expressed regarding the USOAP, the request that USOAP implement adequate requirements so that states could contribute best practices. The USOAP is in relation to safety, and it is difficult to include this requirement. I think the limitations that are faced in supporting these actions does not mean that support is not important, and I think that there are ways, as we have earlier expressed in relation to the forum, to address some of these requests. So whether it is regards to the seminar or to the practice of the insurers, I think all states should take note of the challenges that the victims face, and we can do our best to assist with all these matters. With regards to the seminar, I think that whether it is a dedicated seminar or not, the challenges faced and the support required can always be incorporated into other seminars as well, and this is something that the forum could consider as well. Just a little point regarding the Chinese paper. We thank China also for sharing the approach on targeted and precise oversight. We are always keen to learn from others. We implement a risk-based approach, and we would like to learn from the way that China has tried to address their challenges, because in the context of a rapidly increasing aviation system. If other states are also able to share the experiences, we would also very much appreciate. Thank you very much.
Thank you, Singapore. I see none, so I know that Mr. Huang would like to make intervention. You have the floor.
Thank you, Mr. Chair. I wish to thank Aircraft Victims Family Federations International for putting efforts in presenting this paper. Like many states, Spain, Argentina, Italy, Portugal, Lebanon, Mexico, Finland, Singapore, Secretariat will also support the lofty goal of victim compensation. I had my own experience in 2014 in Ukraine, witnessing the disastrous effects of the victims toward the families. In the case of Malaysian airliners, MA17. So I had that first-hand feeling. And when we work also together with your former chair, Mr. Efrenson, who lost his daughter in one of the terrorist attacks. So we all share this kind of sentiments. The working paper, when it's referred to us, among ICAO, there was some discussion about it is the safety aspect or is the legal aspect. So after certain internal discussion, we referred to this USOP Safety Oversight Program, and some of the victim compensation were handled in the context of Annex 13, accident investigation. We had some internal discussion about where to take this paper. Finally, I, as the Secretary of the Legal Commission, I said, we take it first. It remained the issue is across sectors and multidisciplinary. It's not just legal issue here. There's an insurance matter here. There is an annex to the Chicago Convention. There are also issue of the USOP, Universal Safety Oversight Program, which need to have a global approach. So what I suggest to this distinguished commission is we note the paper and study the issues among ICAO Secretariat and see what will be the possible steps we could do as a approach to this matter. And secondly, regarding the seminar, as the delegate of Singapore has mentioned, this is a very useful topic to be included in the seminar. But whether this is designated to be a special seminar next year, to be honest with you, Legal Bureau doesn't have the budget for that. If the budget can be made available, that's a different story. So depend on the state who sponsor, who support this. If you can support this, that's certainly we are more than willing to co-sponsor it. Secondly, there are also other forums we can include this. So I call perhaps to study the possibility whether the Aircraft Victim Families Federation International next time can send your presentation speaker to some of the seminars that we have. I take this opportunity here to thanks again Singapore for organizing the Legal Advisor Forum, also for Republic of Korea for consecutively in the past 18 years to sponsor Asia Pacific Legal Seminar. And Korea also has a paper in front of us, but because it's an information paper, we did not discuss it. So perhaps in addition to thanking Korea for your efforts, Aircraft Victims Family Federation International may contact them. In their seminar, probably you can send 1 or 2 experts to illustrate what needs to be done in this respect and discuss in that seminar. That would be my proposal for for this item for your consideration. Thank you, Mr. Chair.
Thank you, Mr. Huang, for your observation. Is there any other comment is there any delegation would like to make a comment? I see none. So if you allow me, I just want to make a conclusion of our deliberation. With respect to working paper 325 prepared by China, I think we do what we did. We just take note the working paper and welcoming the information, and we also request China to continue to share their experience with ICAO and member states, which will undoubtedly prove useful to the aviation community at large. And is there any comment on that proposal? Thank you. There is no any comment. So my conclusion for working paper 434, prepared by Aircraft Victim Families Federation International. I think Mr. Huang made a very good proposal. We just take note the paper, and we request the Secretariat to conduct a study on the possible future work on this matter. And on this matter, I didn't really take what is your proposal, but one this matter.
First is the Secretariat involves several multidisciplinary aspects, so we need a comprehensive overall kind of holistic study, and some of them need the help of Air Navigation Bureau. As for the seminar, we have a possibility to include this subject for the next Legal Advisor Forum. And also another possibility is the seminar to be organized by Korea in 2021. Okay. Korea has presented this paper on that.
Thank you, Mr. Huang. So about the seminar, we may include it in the next two seminars on the legal forum, and other in a seminar that is going to be organized by Korea. Yes, Argentina, you have the floor.
Thank you, Mr. Chairman. I have a question. Where is the Council in all this consideration? Because you have the Assembly every 3 years, you have the Legal Committee, but the Council, I'm certain, Dr. Wang, would love to see the study you are going to produce to continue to provide intergovernmental guidance to the work of the Secretariat. Thank you very much.
Mr. Huang, you would like to?
Yes. Well, thank you, the representative of Argentina. Yes, this legal commission would report to the plenary, and plenary would approve the report of this legal commission, and then any guidelines or plan of actions would be transmitted in due course to the Council.
Thank you. Microphone for Argentina, please.
Thank you, Mr. Chairman. I'm saying that maybe this committee should include in the recommendation to the plenary that the report is presented to the Council. My concern is that when we go to the plenary, particularly, you know, they are announcing in all the committees that the building tomorrow is closed at all. So all the activities will go to the weekend. We'll work under pressure, and we may not have the time to go to these nuances when we go to the plenary. So my humble suggestion is that we include the Council in the loop in the recommendation from this committee to the plenary, so we can save some time there. Thank you.
I think this is quite a wise proposal. Can we do that? Okay, thank you, Argentina, for your proposal. Ladies and gentlemen, now I think we are done with all the working papers. The remaining works is only, I just want to share with you, there is one information paper, working paper 544 on remotely piloted aircraft for commercial cargo transport purpose, a challenging opportunity as prepared by Indonesia. I think as we did earlier that we don't discuss it, we just take note of it. I think there is no more business for today. We are arriving. The most exciting part of our business is the end of the meeting. So I just want to consult the Secretariat about the future business arrangement.
Thank you, Mr. Chair. According to the current schedule, we are going to review the report of this commission next Monday afternoon, 2 o'clock, at 2 p.m. at the conference room 2, upstairs, according to the current schedule. Whether there is any change or not, you would have just to watch our website concerning the order of business. If we change it, we will let you know there. If we do not change it, we'll see you in conference room 2, Monday afternoon at 2 p.m. Thank you. The report would be gradually issued depending on the item. The latest part would be morning Monday. You should have the draft report. The report will only be effective when you approve it and present it to the plenary. Thank you.
Thank you, Mr. Huang, for your information. I think if you allow me, we just adjourn the meeting, and I just wish you not happy weekend. No, not yet. Yeah, okay. Just see you Monday afternoon at the CR2. Thank you. Sorry, before I think if you allow me, I was informally approached by the Singaporean delegation that she would like to make a small announcement.
Thank you, everyone. You know how it is with ladies, right? They like to detain you a little longer. So thank you, Chairman, for letting me take the floor. On behalf of the Singapore delegation, I would like to invite all Assembly delegates to the Singapore reception this evening. It will be at Le Paquet, across from the back of the ICAO building beside the W Hotel. Please join us anytime from 7 p.m. till 10:30 p.m. and bring your ICAO Assembly badge or invitation card for identification. We look forward to seeing all of you there. Thank you very much. And thank you, Mr. Chairman.
Thank you, Singapore. One more delegation would like to speak. South Africa.
Thank you, Chairperson. South Africa will just wish to announce that with the shutdown tomorrow, the South African reception that was scheduled for tomorrow evening has now been postponed to Sunday, the 29th of September at 5:30, still in the delegation's lounge.
Delegation lounge.
Thank you.
Thank you, South Africa. Thank you. I think now I can safely say that the meeting is adjourned. Thank you.